Hello everyone, I am Ashok Sahu. I am going to revise the constitutional body of India and I am going to upload this video in my YouTube channel. If you find it useful, you can go through this. So, our first body is Attorney General of India, who is the first law officer of India. Okay. So, Article 76 of Indian Constitution provides for the office of Attorney General of India. To become a Attorney General of India, a person should be qualified to become a Supreme Court judge. So now question arises, what are the qualification of Supreme Court judge? Right? So we can now discuss the qualification of Supreme Court judge. To become a Supreme Court judge, a person should be a citizen of India, which is the foremost qualification. Second, he must be a judge of High Court for at least 5 years. Or he must be a advocate of High Court for at least 10 years. Or he must be a eminent jurist in the eyes of president. Clear? Okay. Now he is appointed by president. He is appointed by the president, but in the advice of Council of Minister. In the advice of Council of Minister. Okay. His tenure is not mentioned in the constitution, so he works on the pleasure of a president. Okay. His ground of removal is also not mentioned, so president can remove him anytime with his pleasure. Clear? And he can also resign by writing his resignation letter to president. Okay. Generally what happens when Council of Minister dissolves or they resign, the Attorney General of India also resigns. Okay. Then his service conditions are decided by president, which is generally equal to Supreme Court judge. Clear? He is assisted by Solicitor General of India, which is not a constitutional body. You have to remember that Solicitor General of India is not a constitutional body. Okay. So composition of office of Attorney General of India not mentioned in the constitution, and he submits his report to president or concerned governor. Okay. Lastly, he is eligible for reappointment after the retirement. Okay, he is eligible for reappointment after the retirement. Clear? Next, move to our second body, which is Advocate General of States, who is the highest law officer of a state. Okay. Article 165 of Indian Constitution provides for office of Advocate General of States. His qualification must be equal to High Court judges. Now, question arises, what are the qualification of High Court judge? Correct? So, let us now discuss what are the qualification of a High Court judge. Okay. Like the Supreme Court judge, a High Court judge must be a citizen of India. Okay. Secondly, he must hold a judicial office for 10 years. For 10 years. Not like 5 years. Okay. He must hold a judicial office for 10 years. Thirdly, he need to be a advocate of High Court at least for 10 years. Okay. There is no mention about the eminent jurist. So to be a High Court judge, one need to be qualified for two conditions. One, he must be a citizen of India, or one between these two. Okay. So next come to our discussion. A Advocate General is appointed by Governor of the state. Okay. In advice of Council of Minister. Now his tenure is not mentioned in the constitution, so he works during the pleasure of governor. Clear? Okay. and he can also be removed by the governor anytime whose grounds are not mentioned in the constitution. So he can be removed by governor with his pleasure. Clear? He can also resign by writing his letter to governor. But generally what happens when council of minister dissolves or council of minister resigns, the advocate general also resigns. Okay, his service conditions are decided by governor, which is generally equal to the high court judge. Okay, he is assisted by additional advocate general. Okay, the composition of advocate general of state's office is not mentioned in the constitution. Okay, so he submits his report to attorney general of India, who in turn submits the report to the governor of the concerned state. Okay, so it goes like advocate general submits its report to attorney general of India, who submit its report to concerned governor of state. Now the advocate general of state is eligible for the reappointment. Okay, now move to our next body, which is comptroller and auditor general of India. He is popularly known as the guardian of public purse. The guardian of public purse, not guardian of galaxy. Okay, so Article 148 to 151 mentions about Comptroller and Auditor General and his responsibility. So to be specific, Article 148 mentions about the office of Comptroller and Auditor General of India. Okay, the qualification of Comptroller and Auditor General is not mentioned in the Constitution. So President can appoint anyone as he finds fit for the position. Okay, so as I said, Comptroller and Auditor General is appointed by President. His tenure is fixed, which is 6 years of office or until he 6 year of office or 65 years old, whichever come first. Okay, so removal, he can be removed in the same manner as Supreme Court judge. So what does this means? This means that Comptroller and Auditor General can be removed only on proved misbehavior and incapacity. Okay, by a resolution passed by both the houses with special majority of 2/3 votes present and voting. Clear? So Comptroller and Auditor General can only be removed in the same manner as Supreme Court judge. Clear? Okay, so he can also resign by writing his letter, resignation letter to President. His service condition is decided by Parliament, not governor, not president. His service condition is decided by Parliament, which is generally equal to Supreme Court judge. Okay, he is assisted by IAAD department. His composition of the CAG office is only one member, himself, and he submits his report to President under Article 151. You can refer to the Article 151 where he submits 3 reports, so you can revise it yourself. Then he is not eligible for reappointment. Okay, clear? Our next constitutional body is Finance Commission, which is responsible for vertical and horizontal devolution of net proceeds. This constitutional body is mentioned in 280, Article 280. Qualification of Finance Commissioner is determined by Parliament. Okay, according to prescribed qualification, President appoints the Finance Commissioner. Okay, so his tenure is generally 5 years, but it can also be less than 5 years when specified by President in his order. Okay, he can also be removed by the President, and he can also resign by writing his resignation letter to President. His service conditions are determined by the President. Okay, the Finance Commission is a 5-member body, 1 chairperson and 4 other members. They recommends by their report for vertical and horizontal devolution to President under Article 281, which is non-binding. Okay, so they are also eligible for reappointment after retirement. So in our next two videos we will discuss about remaining 8 constitutional bodies. Till then, keep revising. If you find this video helpful, please like and comment and share with your friends. Thank you.